Hello, I'm Anitha Mehta, Assistant Professor of SBM JEC. Today we're going to discuss one topic in business regulations, and the topic is the Patents Act of 1970. We have three types of properties: the movable property, the immovable property, and intellectual property. Movable property are dealt under Sale of Goods Act, immovable property are dealt under Transfer of Property Act, and intellectual property are dealt under various acts like the Trademarks Act, the Patents Act, the Copyrights Act, etc. Now, coming to this meaning of intellectual property. What is intellectual property? We say intellectual property is an umbrella term for various legal entitlement which attach to certain names, written and recorded, media, and inventions. The holder of these entitlements are entitled to various exclusive rights in relation to the subject matter of IP. IP reflects the idea that a subject matter is a product of the mind and the intellect. Now, we say intellectual property, the law and enforcement varies from one jurisdiction to other. There is intergovernmental efforts to harmonize international treaties such as WTO agreements on TRIPS, that is, trade related intellectual property rights. This TRIPS deals with various requirements. So TRIPS contains requirements that nation law must meet for Copyrights Act, industrial design, patents, trademark, etc. It is very comprehensive international agreement on intellectual property to date. So a trademark, a copyright or patent rights are important IPRs. They are known as incorporeal assets. As patent, copyright, trademark represent title to property, they can be sold or assigned by owner or holder thereof to another person in accordance with law. Now to start off with the introduction to Patents Act of 1970. First of all, this word Indian Patents Act is contained in Indian Patents Act of 1970, and this has been taken from the English Patents Act of 1949. The word patent is derived from a Latin word which is known as patre, which means to open. Patent is an official document giving an exclusive right to the inventor of new things or new manufacturing processes. After fixed period is over, this right becomes a public right. Therefore, we use the word public juris. That is, any person can manufacture the article, and this patent is granted by the government. Patents Act 1940 was made to protect Indian drugs, pharmaceuticals, chemical industries, and Indian agriculture from foreign competition. Society and individual inventor, the inventor gets an exclusive right to prevent others from making and using, selling a patented invention for a fixed period in return for the investor disclosing the details. In a way, this person must be rewarded for his endeavor. Now coming to this, before we learn what can be patented, we must know the object of the Act. The main object of the Act is to strengthen and amend the law relating to patent, and there are various advantages of patent. That is, it gives exclusive right to the patentee to use the invention. It helps the patentee to sue the person who wrongly uses his patent. It helps the patentee to sell his patent or give license to others to use the patent. It helps the patentee to get patent of addition when he makes improvement in, in or modification to the main invention. Now we must know what is invention. This word has been given more meaning. We say patent is only given for invention. So now invention has been defined under section 2J. So they given you what can be patented. Any invention can be patented. Invention means new product or processes involving inventive step capable of industrial application. Inventing step means features that invention is not obvious to person skilled in that art. So we say invention means an art, process, method of manufacture, a machine, instrument or other articles substance produced by manufacturer, it also includes three basic things. That is, there must be novelty, there must be method of manufacture, and utility. Now, one more question comes to our mind is what cannot be patented? So, these things have been expressly given in the Act. The following cannot be patented. So, they given that anything which is not an invention cannot be patented. It is self understood that if it is not an invention, it cannot be patented. If it is contrary to law, it cannot be patented. Just you discover it, mere discovery cannot be patented, or aggregation of properties or mere admixture of two more things, rearrangement or duplication, method of agriculture, presentation of information, topography of integrated circuits, method of performing any mental act, or invention based on traditional knowledge, literacy, dramatic, musical works, or any artistic creations. This cannot be patented. But they have said you very clearly anything related to atomic energy also cannot be patented. Now we learn the most important part of Patents Act. This is known as grant of patent. So before we proceed to the procedure, we must be knowing certain things. Who should apply? The first thing is who should apply. We say any person claiming to be the first and true and first inventor of the invention. He must apply. Condition. Condition is for each invention, separate application of patent shall be made, and the true and first owner shall apply in Form 1, and the legal representative shall apply in Form 2. Filing of specification. A complete specification must be filed with the registrar of patent within 12 months from the date of filing of application. It can be extended by another 3 months. Provisional specification, that is temporary details, has to be also given, but complete specification gives all the details about the invention, drawings, etc. Once the application has been given, this application is sent for examination. So we say application along with specification will be sent to the examiner by the controller of patent to find out whether the application is submitted according to the requirements of the Act. Once it is sent for examination, the report is being given by the examiner whether he satisfies all the conditions. Refusal of the application. When the application submitted does not comply with the requirements of the Act, the controller may either refuse or ask the applicant to amend the details of the application. Acceptance of the application, that is, if the controller is satisfied every particular given in the Patents Act has been complied with, he accepts the application. Once it is accepted, he has to advertise the acceptance of the complete specification in the official gazette. Application is kept open to public inspection, and if next heading is opposition to grant of patent. This means once advertising is there, within 4 months of advertising, any person who is not happy, he can give notice of opposition to grant of patent to the controller. This period of 4 months is again extended by another one. So the person who has can oppose on any of the following grounds. That is, the applicant who made the patent has wrongly obtained the patent when the alleged invention claim by the applicant has been already published in India, when the so-called invention claimed by the applicant was publicly used, when the invention claimed by the applicant does not involve any inventive step, when the subject matter is not really an invention, and it does not clearly describe what the invention is. On the following grounds, this opposition can be raised. Once opposition is there, the controller calls both the parties, the applicant and the opposed person, and he gives an opportunity of hearing. On the basis of opportunity, the controller decides whether patent has to be granted. After application for patent has been given, the complete specification has been accepted, then and the controller is satisfied, the applicant desires is has done everything satisfiedly, the patent application is sealed. That is, the patent will be sealed with the seal of the Patents Office, and the date on which it is sealed will be entered in the register. It is only after the patent is sealed the patentee gets the right and he can sue the infringer for infringement. Now coming to this patent of edition. Edition is nothing but modification or improvement to the existing invention, and therefore for any invention edition, once again you have to apply for patent. Now they given you very clearly 10 year of patents. The patent is granted under the Patents Act for 20 years from date of filing of the applicant patent. Renewal fees is given at the expiry of the second year from date of patent and therefore for succeeding years. Now we have to learn the most important, restoration of lapsed patent. Lapse means when the patent period is completed, we again restore the patent, giving life to the patent. So this patent lapses for non-payment of renewal fees. It can be restored by making an application to the control of patent within 18 months from the date of lapse. Now the most important thing which we have to learn here is the patentee must give reasons for not paying the prescribed fee in the prescribed form. If the controller is prima facie satisfied that this failure to pay the renewal fees is unintentional, no undue delay was caused in applying for restoration, then he can advertise it in the prescribed manner. So again, notice given to the opposition and the same procedure like grant has to be followed. If no notice is given, if the controller is satisfied, he again gives back the life, and this is clear. The patentee, this is very important, please note that the patentee cannot sue any infringer for infringement of patent between the date on which the patent ceased to have effect and the date of advertisement of the application for restoration of lapsed patent. The patentee can assign his rights to in favor of the aforesaid document must be filed with the controller within the date of execution. Now this is very important, surrender. A patentee can any time surrender his patent by giving notice to the controller. That is, he doesn't want to continue, he can surrender this patent to the controller, and the controller will advertise the application for surrender and invite objections, and thereafter hearing both the parties, he can accept the surrender and revoke the patent. Revocation of patent. The word revocation means taking back the patent. So if the patentee fails to comply with the request of the central government to make use or exercise patent invention for the purpose of the government, if the patentee is not reasonably worked within 2 years of compulsory licensing, central government can revoke the patent if it is exercised if it is against or prejudicial to public interest. Now, coming to this most important thing is known as infringement of patent. The word infringement means your rights have been violated by any other person, that is, be used. Infringement means violating the statutory right of the patentee, his grant and his license. A suit for infringement can only be filed in the district court. The relief which can be claimed are damages, share of profit to the patentee, injunction on infringing event of such conditions. The court can also ask for infringing good to be seized or forfeited and destroyed as the court deems fit. Now coming to this most important thing, the rights of the patentee. Once the patentee gets his patent gets his invention patented, the following are the rights of the patentee. That is, he can sell the whole or part of his property, that is the patent. He can grant license to others to use the patent. He can assign such property to others. Such sale, license, assignment of patent has to be done for valuable consideration. Now coming to this one more thing, right of licensee, where the patentee gives his right to other person, he gives license to use. Then this licensee can use the property to his benefit, and in case of any infringement, the licensee can also file a suit against the infringer in his own name as if he is the patentee. So the period of patent is always for, in respect of process patent relating to drugs and food, the term is 5 years from date of sealing of the patent. In respect of other patent, the term is 14 years from date of patent. And if the patent is to be kept alive, we have to pay the renewal fees. Today, patents are uniformly granted for 20 years. So, for your information, one of the intellectual property is also trademark. Trademark is a word, symbol, phrase, or logo design. It is adopted and placed on the product offered for sale or a container to identify a source. Trademark is an integral part of the firm. So, what is a copyright? We say copyright is nothing but a right that is given to the creator or originator of the work, that is literary work, song, movie, software. These rights are, he alone has the right to reproduce the work, and he can take or distribute copies thereof. Now, one more thing which I wanted to bring to your notice is who is a patent agent. Since all the work cannot be done by the patentee himself, for this purpose he may appoint an agent who is qualified to be agent to do work on behalf of the patent. That is, to draft the specifications, making of the applications, subsequent correspondence, etc. Now, where are the patent office located? We say we have patent office at Delhi, Mumbai, Chennai, having jurisdiction over north, west and south zones. Head office is located at Calcutta, having jurisdiction of the rest of India. With this, we complete the Patents Act. Thank you very much.